Hello aspirants, welcome to Introspection IS. In our ongoing series of prelims PYQs discussion on polity, we are excited to begin a new topic today, that is directive principle of state policy. Kindly continue with us as we carefully analyze this key topic in Indian polity to support your preparations for the upcoming examinations. So let's start discussions. So under the topic directive principle of state policy, we will discuss the very first questions that was asked in 2021. So the question says, under the Indian Constitution, concentration of wealth violates. Now we need, before answering these questions, we need to understand the demand of the questions. So questions क्या कह रहा है? The question says under the Indian Constitution. So it has restrict your thought, restricts your knowledge to answer that under the Indian constitutions, right? So under Indian constitutions, concentration of wealth violates, right? So Indian constitutions जब बात करता है concentration of wealth, कहाँ पर बात करता है? So that we need to answer that, right? So to answer this question, the correct answer is directive principle of state policies, that is DPSP. This has been dealt under Article 39 clause C, concentration of wealth, right? But suppose many of you of view कि right to equality भी तो हो सकता है, concentration of wealth अगर एक जगह होगा तो this will creates an inequality. This may be of thoughts of someone's कि कहीं अगर concentration of wealth हो रहा है, किसी के पास ज़्यादा पैसा आ रहा है, फेवर में है, तो वहाँ इनइक्वालिटी क्रिएट हो सकती है सोसाइटी में. तो इनइक्वालिटी क्रिएट होने से राइट टू इक्वालिटी भी आंसर हो सकता है. But why the right to equality will not be answer to this question is because the question restrict yourself that under Indian constitution. It is talking about under Indian constitutions. If the simple question should be that the concentration of wealth violates, then we can say that equality, it will violates equality. But the try we need to understand the demand of the questions. यहाँ questions हमें restrict कर रहा है that under Indian constitutions. So Article 39 clause C says that economic system does not result in concentration of wealth. तो government के economic systems ऐसा नहीं हो, फोकस नहीं हो कंसंट्रेशन ऑफ वेल्थ पे. इट शुड बी ऑन इक्वल डिस्ट्रीब्यूशन, right? Who are participating, right? So this the right to equality cannot be answered because it has been restricted. Though we all know कि अगर concentration of wealth एक जगह होगी, अगर किसी के फेवर में काम होगा तो वहाँ inequality create होगी. This is right. You are also right. You are also on right track to while if you are thinking this. But the question demands that under Indian constitutions. And this is the beauty of UPSC. UPSC आपको ट्रिक करती है इसी तरीके से कि आपको क्वेश्चंस को बहुत ही कंसंट्रेशंस के साथ और वेरी क्लैरिटी के साथ पढ़ना होगा टू गो टू फाइंड अ कीवर्ड हाउ टू आंसर द क्वेश्चंस, राइट? So right to equality cannot be the answer. The right to freedom is not related to, or it is not been you can say that near to the concentration of wealth. The concept of welfare, though the Indian constitutions has a concept of welfare, but the right answer or the most appropriate answer is DPSP, which aims at creating a welfare state. Okay? Is it clear? So answer to this question is directive principle of state policies. Now let's see the explanations. So Article 39 says that state shall in particular directs its policy towards securing. So what should the state do? So it direct its policy, means it's create its policy towards securing what? Securing what? So it has an six, we can say that clause with respect to Article 39. So securing, first securing that citizens, include men and women equally, have the right to an adequate means of livelihood. So it should secure that everyone should be given an adequate means of livelihood, everyone get an opportunity to provide and livelihood, to earn their livelihood. This is the policy of the state should be directed toward this. The clause B of the 39 says that the ownership, securing the ownership and control of material resource of the community and are so distributed as best to subserve the common good, right? So the concentrations material resource of the community, that is country, should be distributed in such a manner that it should not be useful or beneficial for very limited persons or for a very good uh, that for the limited individuals, but it should subserve the common good, that everyone should get benefit from the material resource, whatever the material resource the country have. Now C, the clause C that the questions related to is that securing the operations of economic system does not result in concentration of wealth and means of productions to the common determined. So the government should direct its policy in like ways that the operations of economic system does not result in concentration of wealth. Like जमींदारी systems की अगर हम बात करें, there was a system that is a जमींदारी system. So जमींदारी system is one of the example how the concentration of wealth is happened during the British era, right? So to avoid this, this has been provided. And also Supreme Court has also directed that in the application of, in the implementation of Article 39B and Article 39C, and if implementation of these clauses violates part third of the Constitution, then also this it cannot be called unconstitutional. Unconstitutions. On the basis of this also, that cannot be held invalid or unconstitutional, because these are the important part through which the community can, or the government or the community can come out from the economic crisis or a poverty. Clear? So this is C. Now if we see the clause D, so securing that there is an equal pay for equal work for both men and women. So this is also the job of the state or the duty of the state, that men and women, they should not be distinguished or they should not be differentiated on a basis of equal pay, in terms of equal pay on the basis of their gender. uh, Clause E says that concentration of wealth, that health and strength of workers, men and women, and the tender age of children are not abused, and that citizens are not forced by economic necessity to enter a vocation unsuited to their age or strength. Clear? So this is the job duty of the state, that they should create certain environment, or they should protect the workers, women, men, women, and that age of tender age of children, that they should not on the verge of their economic conditions, or they, if they have an economic necessity, so they should not take any such job which is not suited for them. Like suppose किसी घर में बहुत गरीबी है, तो बच्चा, the age children should, that should not be forced them that they should work in any hazardous industries. That it will be a violation of Article 24. It says that abolition of child labors. So they should not be forced to join any such condition which is, or any job or any vocations which are not suited to their age or strength. Clear? The next clause of Article 39 is F, which says that securing that children are given opportunity and facility to develop in a healthy manner and in a conditions of freedom and dignity, and that childhood and youth are protected against exploitations and against moral or material abundance. Clear? So these two clauses of Article 39 is important. Why? Because the Supreme Court also held that while implementing any of the provisions under Article 39 clause B and 39 clause C, and if the implementation of this leads to violation of part third, then also this cannot be called under unconstitutional or void. And because of this the two provisions of 39 makes them an important. Clear? So this was the 2021 questions. Okay, chaliye now move to the next question. Now, if we see the explanations of this, so as we have discussed, that right to equality, the right to equality under Article 14 to 18 deals primarily with the equality before law and prohibition of discriminations rather than economic disparity or concentration of wealth. This is, if we see this right to equality is a political right, right? Whereas if we see this DPSP is about to economic justice. So this is a difference between this and a concentration of wealth and talking about the economic justice. Right to freedom, again it's become a political right. Right to freedom from 19 to 22 ensures freedoms like speech, assembly and movement, but does not directly address the issues of wealth concentrations. Concept of welfare, while reducing wealth concentration is a part of welfare concept, the Indian constitution explicitly addressed this issue through directive principle of state policies, as we have already been discussed. Okay, let's move to the next. So next question was asked in 2020. Now it says that in India, in India, separation of judiciary from executive is enjoined by. So separation of judiciary from executive, right? Do the preamble of constitutions talks about the separation of judiciary from executive? No, it does not talk about the separations. It only talks about that objective of constitutions, right? Like liberty, justice, then equality, fraternity, but it does not talk about an separation of judiciary from executive. So this cannot be our answer. Do the directive principle of state policies talks about separation of judiciary from executive? Yes, article 50 of the constitutions clearly mention that the state shall take steps to separate judiciary from, there is a separations between judiciary from executive. So our answer is answer B. So separation of judiciary from executive is talked under directive principle of state policies. The seventh schedule is also not related to. Seventh schedule is basically related to division of power. Division of power, right? That the power has been divided between the two government, the central government and state government through list. This has been done through the seventh schedule list, that is talked about the list, union list and state list, and one is concurrent list. Concurrent list, but it has nothing to do with the separation of power, right? Separation of judiciary. So this is also why you understand why this cannot be the answer. The conventional practice, the conventional practice is something like which is been dealt, though we know that the constitutions or the India is governed through the conventional practices also, but this has nothing to do with the separation of power. So this cannot be the answer. So our answer is directive principle of state policies. Now to understand this in a very elaborate manner, we can see through this one of the judgment of a Supreme Court in NJAC Act. So if you remember, through the 99th Constitutional Amendment Act, through the 99th Constitutional Amendment Act, the government come up with the NJAC Act, that National Judicial Appointment Commissions. And in this and this through this act, the government tried to replace the collegium system. Collegium systems. So what happened in this act? That it has given an executive to involve in the committee for recommendation of appointment of judges. So this was the case. So the judiciary under the NJSA Act has called it unconstitutional on the ground of the first that it violates Article 50 of the Constitutions, where the Article 50 says that judiciary should be separated from an executive. It means the executive shall not be interfering, or executive should not be in a there should be a clear-cut distinctions between the judiciary and executive. Now, why it is necessary to have a separations between executive and judiciary is because through this it maintains the independence of judiciary. And independence of judiciary is a very necessary or important features which keeps the constitution intact. And because of this nature, or because of this objective, to achieve this objective, the Article 50 talked about the separation of judiciary from executive. Is it clear? So now let's see the Article 50 of the Constitution. So Article 50 talks about separation of judiciary from executive. The state shall take steps to separate the judiciary from the executive in public service of the state. The purpose of this provisions is to ensure the independence of the judiciary from the executive branch, which is essential for upholding the rule of law and maintaining impartiality in the administration of justice. This is the objective of Article 50. This separation is critical for the judiciary to act as a check on the power of the executive and legislative branches. Clear? So the, as we have seen, the preamble does outline the ideas of justice, liberty, equality, fraternity, but it does not specifically mandate the separation of judiciary from executive. The seventh schedule of the constitutions deal with the division of power between the union and states government through union list, state list, and concurrent list, but it has nothing to do with the separation of judiciary. It's clear? So this was question in 2020. Now let's move to the next question. Next question was also asked in 2020. So the question says, which part of the Constitution of India declares the idea of welfare state? So it means it is basically asking the objective of, or achieve of, which part of the Constitution of India is objective to achieve an welfare state. So all we know that it is a directive principles to of state policies to achieve an welfare state, not a fundamental rights. Why? Because fundamental right is concentrated or available to the individualistic. So fundamental right is basically an personal or individualistic, whereas directive principle is for the community good. And a welfare state means doing a welfare to the people of the country through providing them an opportunity of status and employment to enhance their economic conditions. That is welfare state. That is to be done. That's directive principle state policies address the government to achieve an welfare state. Right? Preamble has not mentioned, or preamble is not, as we have already seen, it is just an preamble is just a part of the constitution, and it is an we can say that preamble is a key to constitutions. It has objective only to achieve objective mentioned in the preamble is liberty, equality, justice, and fraternity. Right? So seventh schedule is, again we have seen, it is an division of power between two government, that is central and state government, through the list. So it is also not about a declares the ideal of welfare state, right? So it is only the directive principles of state policy which try to achieve a welfare states. And these are this seventh schedule is basically a mechanism. So we can say that if we talk about the means and ends, so welfare state is an end where the government want to established, and the seventh schedule we can call is a main means through which it allows the government to form a policies, and the main objective of the policy is to achieve a welfare states. Clear? So if you see the idea of a concentration of wealth, so idea of a welfare state, sorry, not concentration of wealth, but a welfare state, is explicitly reflected in part 4th of the Indian constitutions, which contains a directive principle of state policies. These principles, enshrined Article 36 to Article 51, are guidelines for the state to frame laws and policies that promote social, economic, and political justice, aiming to establish the welfare states in India. Okay? So clear? Now the key feature of welfare states, such as reducing inequality, providing adequate means of livelihood, ensuring education, promoting health, and securing social justice, are articulated in these articles. Now, for example, that which of the articles of the directive principles of state policy, that is part fourth of the constitutions, uh, explicitly deals towards the focusing towards achieving a welfare state. So first is article 38, which talks 38 talks about that it directs the state to strive to promote the welfare of people by securing a social order based on justice, social, economic and political justice. Article 39 focus on distribution of resources to serve the common good and prevent concentration of wealth. 39b and c, through b and c, especially it is trying to achieve the social welfare or welfare state. Article 41 provides for the right to work, educations, public assistance in case of unemployment, old age and sickness. So like government providing an any schemes for old, or pension schemes like Atal Pension Yojana, right? So all this is related to old age. So it means that it is providing an welfare state, providing an old age also not to be felt left out. They should also um, felt to be, or they should also feel inclusive. Article 47 that enjoins the state to raise the level of nutrition, improve public health, and prohibit intoxicating substance. So these are the certain examples of the DPSP that articles provided, how which shows that how the state, this part is guiding the state to achieve a welfare states. Clear? Let's move to next questions. So next question was also asked in 2020. So it says that with reference to the provisions contained in part 4th of the Constitution of India, which of the following statement are correct? So basically this is asking about the part 4 of the Constitution of India. So if you see, this part 4 belongs to the directive principle of state policies, which dealt through article 36 to article 51 of the constitutions, right? And as we know that part third of the constitution belong to fundamental right, which has been dealt through article 12 to article 35. Then part second of the constitution, it is about citizenship, that is dealt under article 5 to 11. The first part is territory of India and India and its territory, India and its territory. This has been dealt through article 1 to article 4 of the constitutions, right? And if you see the part 4th A, that is fundamental duties, article 51 A of the constitution. So these are the certain parts of an Indian constitution. So now this question is related to part 4th of the constitution, that is directive principle of state policies. Now let's see. The first says they shall be enforceable by courts. Now to answer these questions, we should understand one thing. That this part 4's nature or characteristic of the part 4. Now, as we know that part 4th, that is DPSP of the Indian Constitution, is a guiding principles. This is a guiding principles, or we can say that it is a guideline for the government, for the government, how to work. Right now, this guidelines or you can say that principles cannot be enforceable, cannot be mandatory, or cannot be enforceable in a court of law. Now the reason given by the court of this, or the framers of the constitutions, why they have put this part fourth, that is DPSP, under the not enforceable part of the constitutions. Why? Because it's the providing an adequate means. If you see the articles of this part, that is provide certain articles like providing adequate means of livelihood, right, providing educations, providing health care, right, or providing free free legal aid service, or etc. All this requires an huge investment of economic or finances, right? So it means first the government has to be well off from its economic or finances, then only they can provide an adequate means of lives, right? So because of this, that India during its independent, when it got an independent, and during when it formulated or imposed the constitutions, the economic conditions of India was not so good. There were many factors which shows that the economic at the point of time in 1947 1950, when the deliberation of constitution was going on, that it has a very poor economic conditions, and that poor economic conditions has become a factor that it provide that this part fourth of the constitution should not be an enforceable of court. It means the court should not interfere giving directions to the state while implementing this, to implement these articles, right? And because of this nature of the non-enforceable of this nature, we can say that the court in India never direct the state to formulate a law, a government to formulate a law. They only suggest them that the government should come up with this law. They only give suggestions. So they're not in a positions to direct them, that they are not, because this part fourth of the is not enforceable. So if some government do not do this, some government do not come up with this any scheme, so no one can move to the court and ask the court to enforce them, right? To enforce them to make some laws, or to make some laws, or to provide any laws, or amend this, or do any certain things. Why? Because the constitutions has directly restricted the court that they should not interfere in the working of the government, and this shows the one of the features of separation of power, right? And because of this, the court never directed or given a mandatory or ordered the government to formulate a laws. It only requests them or suggests them that government should come up with these laws to avoid certain circumstances or situations. Clear? So because of this, we can say that they are not enforceable by court. So part 4 is not enforceable in court, in court, but part 3rd of the constitution that talks about the fundamental rights, they are enforceable in a court of law. So this cannot be our answer. And if we go through the elimination method, we need to find a correct answer. If we go through the elimination method, so first cannot be answer and the third cannot be answer. So you are left with the B and C. अब B और C में अगर आप देखें तो second is a common, so second must be true, right? The second says that they shall not be enforceable by court. Yes. Now if we go through the first two, this is true. Now if you go to the first and second statement, तो आप देखिए तो first और second both are contradictory to each other. एक कह रहा है कि है, एक कह रहा नहीं है, तो कोई एक ही ट्रू हो सकता है. It means the both cannot be true at the same time. So if first is wrong, second is true. Clear? Now move to the third. The principles laid down in this part are to be influenced the making of laws by the state. Yes, this is also true. And these two part, second and third point of the question is been mentioned in the article 37. So there is a specific article for this, that is article 37 of the constitutions. And as we know that DPSP, as we have already seen, that DPSP part 4 is a guiding principle for the government. It means it is influencing the making law, a law of the state, that the state should make law according to the provisions or the guidelines provided to them through the Indian constitutions. So our answer would be for this questions is D, that is 2 and 3 both. Is it clear? Okay. Now if it's as I said that these two provisions were directly mentioned in the constitutions under article 37. So according to article 37 says that part 4 shall not be enforceable by any court. This is mentioned in constitutions, right? It also says the principles therein laid down are nevertheless Fundamental in the governance of the country, it means they are the fundamental, it is means important, and the government should follow this. It shall be the duty of the state to apply this principle in making laws. So we can say that it is a bonding, or it is a it is mandatory for the government, for government to apply these principles while they are making laws. So it means they have been, the laws of made by the states are influenced by this part. It's clear. So this is a part question 4th of the under DPSP. Now let's move to the next question. Now next questions was again, it was asked in 2020. So it says that in India, legal service authorities provide free legal services to which of the following types of citizens? So it is talking about it, that there is a authority, that is legal service authority, to provide a free legal services. Now this free legal services is a fundamental right of an individual under Article 21 of the Constitutions, right? So Article 21, that talks about the life and personal liberty. It includes a right to free legal aid. To whom? Not to everyone. That has to be understood. This free legal aid is not available to everyone, but those who are lacking in those who are lacking in financial conditions, जिनकी financial conditions अच्छी नहीं है, जो afford नहीं कर सकते हैं lawyer, advocate को to represent their case in a court. So it is a duty of the state to provide them a free legal aid. And to provide this free legal aid, the free legal aid authorities has through Act 1987 Act, the government has come up with the Free Legal Service Authority Act 1987. Through this, state provides a free legal services, right? Now to answer this question, that which of the following type citizens are involved or provided with the with the legal services, right? So first of all, we need to understand this is only not to everyone, but is only to the those who are not a financial well off, जिनकी conditions अच्छी नहीं है, सिर्फ उन्हीं को ये services मिलेगा, right? So the persons with an annual income less than 1 lakh, so less than 1 lakh, अब एकदम आप इसको factual, this is a factual, so till we cannot incorrect, but we call if you are not going to make it correct, but we cannot also make it incorrect, क्योंकि financial conditions की बात है और annual income 1 lakh, it means it is somewhere talking about less than we can say that it is about less than 9,000 per month, so it may include in it, right? So this can also be, चलिए इसको for the time being अगर हम नहीं इस position में कि इसको incorrect करें तो correct करें तो we cannot make it also incorrect. So let it see what else options we can get, right? So transgender with an annual income of less than 2 lakh. So transgender, now as we know that India, under Indian Constitution, the discrimination is prohibited. So it cannot discriminate on the basis of sex or gender. So yes, it may be possible that this legal aid services might be provided to transgender also. So let's take it, move to the next, move forward. Member of the other backward classes, OBC with annual income of less than 3 lakhs. Now again, making to someone member of or some community into the act, making it a discrimination. So this may also not be the answer. अगर हम लॉजिकल चलें कि ओबीसी को दे रहे हैं, एससी एसटी को नहीं दे रहे हैं, या बीसी को नहीं दे रहे हैं, सिर्फ ओबीसी के लिए हमने मेंशन किया, इट मींस वी आर मेकिंग डिस्क्रिमिनेशंस. सो दिस लॉजिकली दिस कैन नॉट बी द आंसर, right? Next, all senior citizens, no, this cannot be the answer. Not all senior citizens. Why? इस senior citizens में कुछ ऐसे भी होंगे जो financially well off होंगे, जिनका बहुत अच्छा conditions होगा financially, राइट. लाइक अगर मैं एग्जाम्पल की तरफ बात करूँ, बॉलीवुड स्टार्स, बिजनेसमैन, दे ऑल आर सीनियर सिटीजन, दे आर ऑल आर अबव 60 and 70s. लाइक if we take one of the greatest बॉलीवुड स्टार, और क्रिकेटर्स जो हैं वो सब वेल ऑफ हैं, तो क्या उनको भी फ्री लीगल एड सर्विसेज है? नहीं. दिस इज ओनली मेंट फॉर दोज who have been lacking in financial conditions, who are not in a positions to engage a advocate to represent their cases, just because they have been no financial status or they have no financially well off. So this cannot be our answer, and this can also not be our answer because it is specifically mentioning only one category. So यहाँ पर डिस्क्रिमिनेशन दिखा रहा है. अगर फ्री लीगल सर्विसेज अथॉरिटी एक्ट इज available, or if it is making one community as a giving provisions, this means they are making discriminations. So this is a ground on which it can be, we can say that, unconstitutional. So fourth cannot be answer. So our answer cannot be B, our answer cannot be D, because fourth cannot be answered. Now if you see the A and B, we are left with the A and B, that is 1 and 3 and 2 and 3. So this says on the logical ground कि ये अगर एक ही members को target कर रहा है और एक ही members का provisions दे रहा है, it means it is making discrimination. So this cannot be also answer. So on the logical ground also हम कह सकते हैं this is not an answer. So we're left with the 1 and 2, that is this transgender is also been included along with the men and women. It means it is following the natural justice policies, that it is not been discriminated on the ground of gender, sex, or on gender. Clear? So this shows that our answer is 1 and 2. Though it is a factual question, though it is a question based on facts, but if you are not remembering or if you are not in a position to recollect the facts, so on the logic we can go through to answer these questions. Now if we see this Free Legal Service Act, so this has been provided through Article 39. Also here we have seen that it is a fundamental right, and also under Article 39A, it is a duty of the state to provide free legal services, and to promises or duty to fulfill its duty under 398, the government has come up with the Legal Service Authority Act 1987. So 39A says that equal justice and free legal aid, that was added by the 42nd Constitutional Amendment Act 1976. It says that the state shall secure that operation of legal service promotes justice on the basis of equal opportunity, and shall in particular provides free legal aid. It is a duty of the state to provide free legal aid by suitable legislations, through suitable legislations, and this has empowered the state to come up with this act or schemes or in any other way to ensure that opportunities for securing justice are not denied to any citizens by reason of economic or other disability. So agar economic conditions kharab hai, तो it does not mean, and if the state is not in a positions to provide a free legal services, that it means it is denying the natural justice, which everyone deserves a justice irrespective of their economic conditions. So this Legal Service Authority in India, established under the Legal Service Authority Act 1987, provides free legal services to specific categories of citizens. Yes, it is provided as specific only to those who are lacking in economic or other disabilities. These services are aimed at ensuring justice for marginalized and disadvantaged groups. Clear? Now let's see the act. What does the act says? So it acts as the free legal aid is available to individuals whose annual income does not exceed the prescribed limit, typically to 1 lakh, but this may vary depending on the state or types of legal aid, right? So it is up to the state, but the minimum, it says that it should not be exceed than 1 lakh. So this is available, and it says that this available to individuals whose, so it is not discriminating. It said that it is to individuals, right? Now transgenders are eligible for free legal aid if their annual income is below 2 lakhs. This reflects the progressive inclusion of transgender individuals in welfare schemes, right? OBC members are not specifically entitled to free legal aid based on income criteria under the legal service authorities. The eligibility depends on broader categories like economic criteria, disability, or other marginalized status, not specifically to OBC membership. Senior citizens do not automatically qualify for legal aid. Eligibility depends on their annual income, which must typically fall below a specific threshold, that is 1 lakh, and this should be vary from state to state. Now, the Legal Service Authority Act provide free legal aid to scheduled caste, scheduled tribes, and other marginalized communities. Not OBC is not mentioned under this. Victims of human trafficking or beggars, women and children, persons with disability, individual facing specific vulnerability like custody, disaster victims, person with income below the prescribed threshold, that is on the economic conditions. So these are the conditions on the basis of which a free legal aid services provided to individuals. Is it clear? So this was a questions related to free legal services.